Present.
Well, welcome everyone, and thanks for joining us for Custody for Abused Immigrants, Tips, Tools, and Best Practices. I'm Judge Rosemary Collins. I'm the presiding judge for the family courts in Winnebago County, Illinois. And I want to, at this time, just give you a brief overview about what we're going to be going through today. We're going to be talking about the intersection of immigration law and family law, particularly with what we do every day is with custody, protection orders, immigration status, and a brief overview of U visas, T visas, special immigrant juvenile status. So we're going to, I'm going to have the other presenters introduce themselves at this time. Judge Weir?
Okay, hi. My name is Mary Weir. I'm an associate circuit judge in Jackson County, Missouri, which is Kansas City. And I've been on the bench 5 years. And prior to that, I worked as an attorney working with victims of domestic violence and immigrant victims, of course, for 12 years through a civil legal assistance grant through the Office on Violence Against Women, and I'm happy to be here.
Good afternoon, everyone. My name is Leslie Orloff. I direct the National Immigrant Women's Advocacy Project, American University Washington College of Law. I'm very happy to be here. This kind of a webinar, the family law-based webinar, is the kind of thing that the judges on this, that are faculty here, and I've been, another team of judges, additional judges, have been doing training on nationally for judges across the country. And it's near and dear to my heart because I started my career as a family lawyer and really am very excited to be able to share some tips and best practices and tools that'll help you either decide cases if you're a judge or in a court system, or adjudicate cases if you are a family lawyer or a victim, helping a victim, supporting victims through the process of a custody, divorce, or protection order case. And we'll be talking this afternoon about how immigration issues come up and how they overlap and how an understanding of current immigration laws and policies and remedies available to crime victims will help improve outcomes for immigrant, domestic, and sexual violence victims and their children in family court cases.
Well, thank you very much, Leslie. Judge Weir, it's always a pleasure to present with you. I'd really like to see who else is here with us today. So if you could look at your computers and check the box that best describes you. If you're a judge, attorney, domestic violence, sexual assault advocate, if you could check that box, that would be very helpful to us to see who's joining us here today.
And if you're an attorney working for the court system, please check off court judge or court staff. So it looks like we have a few people from the court system. About 40% of you are attorneys and another 40% are victim advocates. Those of you that put other, if you could type what other is in the chat box, that would be very helpful to us. So as we, thank you very much, NCJ, FCJ for the poll, and we'll move on. So we'd like to, just to get started, I want to talk just very briefly about immigrant demographics in the U.S. and what some of you might be seeing in your communities. About 13%, a little over 13% of the U.S. population are foreign-born. Almost half are naturalized citizens. What's really important for family law cases is about 25% of children under the age of 6 or under the age of 18, almost 26%, have one or more immigrant parents. So you're going to see a lot of families before the court who are of what we call mixed status. They're people that have different immigration statuses within the same family. And that 85% roughly of immigrant families are mixed status. That can include a various mixture. It could include a domestic violence perpetrator, spouse, let's say, who's a citizen or lawful permanent resident, a citizen child, and then other undocumented family members. And what's also important is that the proportion of children in the United States that are immigrants or live in immigrant families is quite high, as I said earlier, 26%. And then finally, as we're talking about, interaction with the courts, the need for interpreters is quite high, is very high, and planning that interpreters are available is really, really important because at least 18% of the U.S. population ages 5 or older speak a language other than English at home and may very well be limited English proficient.
Okay, and so this is Judge Weir. Why do we care about immigration relief when it comes to family law cases? Is there an impact? Is it positive? Is it negative? Should it even be looked at? So if we go to the next slide here, we're going to ask you folks, how do you think filing for immigration relief can help an immigrant, domestic, or sexual violence victim in a family law case? What are your thoughts on that?
So please type your answers into the chat box so we can see them and discuss them. I see that a number of you are typing. Wait a second. So it removes a weapon that the abuser can use. It takes away an element of control. People can access U visas.
Right. Financial security in the long term, that's great.
Judge Weir and Judge Collins, do you want to talk about some of the things you've seen in your courtroom while we're waiting for some of this to come in?
Well, in my courtroom, this is Judge Collins, in my courtrooms, what we see are primarily the financial relief is critical. We know that with our orders of protection, the most often stated reason that the victims go back to abusers is for financial relief. So we see that a lot. We also see a lot of people who are now afraid to access the system because they're being threatened with their immigrant status. So that's a real barrier that we're seeing to people walking in the door.
And one of the things that someone mentioned has to do with stability in the home and safety and security. And one of the things that we know from working with immigrant survivors is, because of how much immigration-related abuse and threats of deportation are used by perpetrators as a tool of power and control, that safety and security against, or being less fearful that there might be immigration enforcement, and immigration enforcement too often could lead to separation from children, for example. Those kinds of things are all kind of wrapped up together when we talk about immigrant survivors. Back to you, Judge Weir.
Okay, and there. Okay, so so the importance of immigration status. You've all been mentioning. Everybody's been talking here about different things. It really does provide a safety net. And when we're talking about, these are things that those of us who are not immigrants, we take it for granted. The ability to go to work and be there legally, not be concerned that somebody's going to bust in and pull us out and being ICE, to be able to have protection from deportation and removal. The ability to obtain a driver's license and a Social Security number, to be able to have access to those things such as housing and public services. Again, economic issues, people not having to be on the streets, being able to access the services that are available. Gaining independence. We know how isolated our immigrant populations feel. And, coming to court, getting appropriate remedies, it does help folks gain independence. Again, ability to travel and, in the end, the path to lawful residency and ultimately, hopefully, citizenship. So, the purpose, again, is access to justice. Are we, as judges, promoting access to justice if we're ignoring the relief that is available to immigrant survivors? And I'll be honest, a lot of judges just don't know what immigration relief is available, and a lot of times attorneys will make representations. Sometimes they're misrepresentations as to the rights of an undocumented individual in the courtroom, and it's important for the judges to understand so that we really can facilitate access to justice. It also does help building community policing and relationships, increasing the prosecution of perpetrators. When victims feel that their rights are protected, there's more willingness to come forward. They're reporting crimes without fear of deportation, and as Judge Collins talked about, willingness to come to court. It improves their options for stability and economic security. This is what we want for all families, and this is what should also occur for our immigrant survivors, and we want to keep communities safe.
So many of you wrote this in the chat, but when we talk about immigration-related abuse that occurs, that perpetrators of domestic and child abuse, sexual assault will use against the victims, it includes everything from a refusal to file papers on somebody's behalf. So if you're married to a U.S. citizen or lawful permanent resident, they can file papers for you, but they may refuse to do so. They may file and then withdraw them. They might force a survivor to work with false documents, and lots of threats to and attempts to have the victim deported, calling the Department of Homeland Security or ICE to turn the victim in or try to interfere and have her case denied are the typical things we see. And that as a result of immigration-related abuse, power and control, and the isolation that Judge Weir was talking about, and that some of you were talking about as well, we see higher rates of domestic violence generally experienced by immigrant survivors. And that those abuse rates reach almost 60%, which is almost 3 times the national average when you're talking about U.S. citizens, immigrant victims, spouses of U.S. citizens particularly. And that when in a domestic violence context, when a perpetrator can control the immigration status of the victim, over 70% of the time the perpetrator never files, and when he does file papers, the abusive spouse delays almost 4 years. And that this immigration-related abuse, power, and control happens in about 65% of the domestic violence-related relationships. And that what we found is that when we did research is that immigration-related abuse is 10 times higher. It correlates strongly with physical and sexual abuse as opposed to psychological abuse. So you have relationships where there's psychological abuse, maybe even extreme cruelty, and you may not have this immigration-related abuse. But when you have it, it's like that cut telephone cord in the old days when we were training on domestic violence. It's evidentiary support for the fact that the physical and sexual abuse is occurring.
And Leslie, if I could just jump in,
Sure.
This is really an important factor. People have to understand that attorneys in your communities that are representing folks in our courts have to be able to present that to their judges. The more informed the judge is on understanding this immigration-related abuse. When I worked as an attorney, the opposing side often brought up, she's not documented, and they've been married 10 years. And, I was like, fine, thank you. You just teed that up for me because I knew that my judge was trained and understood that. And the question was, you've been married 10 years, you're standing here and you're saying you love her, yet you haven't filed her paper. That's so you can keep control of her. I mean, these are things that are important for lawyers to understand, and of course judges, and we're doing what we can to train judges on immigration-related abuse, but it's very important to understand. It's not filing your spouse's papers is not, it's a matter of controlling that person. It doesn't exemplify a loving partner. So I just like to reiterate that.
So one of the things that we see, somebody typed in the chat that I'd like to ask the judges, so somebody said that there's a judge who said they wouldn't, if they become aware that somebody who's seeking a protection order is undocumented, they'll call ICE. Is that best practice for courts?
Yeah, that is not best practice for courts. Obviously, that has a chilling effect on access to justice. I mean, what that really does is send a signal to the community that immigrants need not come into that courtroom at all, or they will be turned over. So that's a real serious problem.
And in fact,
yeah,
it has come up in the past at a couple of times, and there were judges that were taken out in some states from protection order court who were doing this. It's not the first time this has happened. But I think what's really important to understand is when we did some social science research looking at, in 2016 and 17, victims' willingness to come to court for protection orders and call the police for help, et cetera, in communities where courts were welcoming of immigrants, they provided interpreters, they signed U visa certifications, signed SIJS orders, findings. They were sent and did, had good relationships in their communities with immigrants, where immigrants felt welcome. We were not seeing a fall-off nationally in the willingness of victims to seek protection orders. But where judges take a different approach, there can be a direct correlation.
And I don't know if there's any way to have somebody sit down with this judge and talk to him. I don't know where the Eighth Circuit is in Florida, so I don't know if there's a court community council or somebody that can sit down with this judge. I mean, there's always the option of change of judges if that individual is, it says he's been talked to but will not listen. I don't know if it's a small area where a change of judge is, just not available because he's the only game in town. But I agree. I think it's terrible, and it's really flies in the face of access to justice.
And I think the point...
Go ahead,
Judge Collins.
Oh, okay. So sometimes, too, if you can't reach that particular judge, you can reach their supervisors. So you can talk to the chief judge of the circuit, or you can talk to the statewide judicial training branch to talk about that, because it's important that that judge get the information about what a chilling effect this is having on safety in the community for everyone, not just immigrants, but for each and every one of us. And so I would recommend, too, if that judge can't be talked to personally, go up the ladder to talk to other people to get that judge the information they need to make the correct decisions.
And that's a really good transition to one of the things that's important when we look at the forms of immigration relief to doing in judicial training, as well as training all of us, is to understand why Congress created VAWA self-petitioning U visas and T visas as a form of immigration relief. And as Judge Collins said, it's really to enhance not only the safety of the victim and hold perpetrators accountable, but when you hold perpetrators accountable, communities are safer. So let me give you an example. We do a lot of training of law enforcement. And we did a training outside a major metropolitan area once, and there was an officer in plain clothes sitting in the back of the training room, quiet most of the day. And then we asked people to share stories about any cases they knew of where the U visa had been helpful to them. And he raised his hand and he said, I was embedded, my partner and I were embedded in a gang. The gang member's girlfriend was abused, learned about the U visa, was working with an officer in my department on the U visa, had gotten a certification, had a pending case. She then heard from her abusive boyfriend that they had identified me and my partner as undercover agents and put a hit out to kill us. She called the U visa certifier, and they took the guys out undercover and saved their lives. And so that's what's going on, so that it's in everybody's interest. Everybody benefits when these programs work and the remedies are available. And we have Judge Collins and Judge Weir are two of our 7 national team of training judges that are mentoring and talking to other judges around the country on these issues and are available to give one-on-one technical assistance to judges. And we are actually going to be starting up a state team of judges. We're in 5 states now, and I believe I just found out yesterday from the Office of State Court Administrator in Florida that Florida will likely be the 6th state. So there may be some additional assistance we can offer there. But that's what these forms of relief are about and how they can be helpful. This is a very handy tool that was developed by the Department of Homeland Security that summarizes the major forms of immigration relief available to help immigrant victims. Some judges will have these available in public information in their courthouses and will, provide them so people can learn what remedies are available because of the fact they've come to court. It's an avenue to learn. Some judges even have put them up on like a bulletin board in the courthouse.
Really important for advocates to use this too, because it can also help you decide where you need to send your victim survivor that you're talking to get the kind of help they might need.
So VAWA self-petitioning is one of the forms of relief that's available, and it's available to immigrants who have been subjected to battery or extreme cruelty, and we'll get into what that means, by a U.S. citizen or a permanent resident. It can be your spouse, a parent, or you can be the citizen, adult son or daughter over the age of 21. So it can be with whom the self-petitioner resided. There is not a time period required. There is a requirement of good moral character, and that is something that can get tricky. How do they define good moral character? And, so you have to be careful about your clients possibly agreeing to orders of protection and then turning around and getting charged. We've seen people coming in to order of protection court, and everybody says, well, we'll just agree. He's filed now against her, and they're all going to agree and get an order of protection, and next thing we know, she's being charged with violating it. Sometimes those are setups. That's something to be careful. A lot of people think it's innocuous to have somebody agree to an order of protection, and while that in and of itself, I think, Leslie, wouldn't necessarily, having the order of protection against you, implicate your moral character, a criminal charge for that or a conviction for violating an order of protection certainly would.
That's true. And any criminal history can be problematic in terms of good moral character.
So for the advocates, oh, sorry, Mary.
Yeah, go ahead. No, go ahead.
For your advocates, it's important then we have many times that victims are also charged with battery when the police get on the scene, and victims often will go in and plead guilty. They say, yeah, I scratched him. Now he may have been choking me or strangling me. So it's really important that you get this kind of information to the defense bar too, so that they know there are consequences if they let their client plead guilty to a crime, even if it means very minimal sentencing. There are substantial consequences.
That's right. The other requirement there was a good faith marriage, and then VAWA cancellation of removal has similar eligibility requirements. And Leslie, I see there's a question up here about the abuser's spouse.
So I think so what's interesting, one question you're asking about, can a USC so what happens is in a normal situation, when somebody gets married, if there's not abuse, typically they'll file a family-based visa petition. And if the spouse does that, and the victim will often get what's called a conditional green card. They'll get a conditional permanent residency that lasts for 2 years. Just like in VAWA self-petitioning, where you can show, one of the elements is you can show you suffered battery or extreme cruelty. If somebody has a 2-year green card or lawful permanent residency, they can file a battered spouse waiver, which is another form of immigration relief, by showing that it was a valid marriage, a good faith marriage, and that they were battered or subject to extreme cruelty. So it's another option for people with that 2-year kind of wait period before they get their full green card. And that agreeing to a mutual restraining order, if that restraining order is enforceable under your state protection order law, then that agreement could set you up for violation of the order, which is a deportable offense.
And that, Leslie, there's also a question up about undocumented folks working under the table, and does that go to good moral character?
That's actually a really interesting one.
Yeah.
It's interesting because people, the whole system, as you might imagine, the IRS has some interest, in collecting taxes from anybody they can. So there's an option. There's a way that somebody who's working undocumented can pay taxes. And in fact, when people have a path and can apply for lawful permanent residency, if they've been working in the past, there's a mechanism, they can show good moral character by having paid taxes on that money that's earned. So it's a bit more complex, and from a child support perspective, they always look at one of the elements of good moral character is one of the things you want to show is if you had children and you weren't the custodial parent, that you paid child support is one of the elements or ways you can show your person a good moral character. So there are mechanisms that can encourage payment of child support, and why having court-ordered child support through the courts can be a good thing for a non-custodial parent to have, so that if they have a path to legal status, they can show they've been paying their child support. Okay, let's go on to...
Okay, so... Oh, go ahead.
No, it's yours.
Okay, so folks, how... extreme cruelty, how would you define that? Any examples of what you think?
Can you type in the box what you think are examples of extreme cruelty that wouldn't be battering or sexual assault, for example? Well, people are typing.
Well, if not, that's okay. We can go to the slide. So we'll go to the next slide. And
forcing the survivor to remain in the family home, no food or financial support, threatening the children, neglecting food, coercion, verbal abuse of kinds, jealousy, controlling. Okay?
Very good. Very good. So here's our list. Forms of extreme cruelty. Emotional abuse, some of those are contained in what you had just written. Economic abuse, we see very common. Leslie's already talked about the high incidence of sexual abuse. Coercion, deportation threats, immigration-related abuse, intimidation, social isolation, goes right in line with keeping them in the home, not able to work, those types of things, or go to school. Degradation, possessiveness, harming pets. So these are all examples of forms of extreme cruelty.
And one thing I want to mention on this is that with extreme cruelty, it's important to understand that anything that would be enough for a state protection order in any state, or enough for any kind of a criminal domestic violence case in any state, is more than extreme cruelty. It is at least extreme cruelty, if not more. There are elements of extreme cruelty that you could prove for immigration relief that would not be sufficient to get a protection order. So it's important to understand that distinction.
So when you have somebody and you're wondering about U visa, you can go back to that shield, and that will help you too. But this is kind of a summary of U visa requirements. You have to be a victim of a qualifying criminal activity. You have to be helpful, either that you have been, is being, or likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing. We'll discuss helpfulness in more detail, but really it's not as high of a standard as a lot of judges might think. So helpfulness can be calling the police. Helpfulness can be going to get your order protection. So many things suffice for the standard of helpfulness. You must have suffered. Go ahead.
Go ahead, Judge Ware.
No, that wasn't me.
Oh, okay. I was going to add, helpfulness can be raising domestic violence or child abuse in a custody proceeding, and where the only contact that the victim has had with the justice system has been the courts. same thing in a protection order context. It can also include anything that victim might have done with the police or the prosecutors in a criminal proceeding.
And it doesn't have to be helpful throughout the entire proceeding. So if they do help the police at the beginning and then they don't at the end, that does not destroy their helpfulness requirements. So they also must have suffered substantial physical or mental abuse as a result of this victimization. They must possess information about the crime, and the crime must have occurred in the U.S. or violated U.S. law. So that's what you need to look at to see if you have somebody that is actually maybe eligible for a U visa. Now, these are complicated things, and so we're just going through them very quickly. But again, I would urge you to go back to the earlier materials on that shield if you want to go over this in more detail. And there's more detail about all of these on the website for NIWAP. T visas are very nicely keyed up with what they're for. They're trafficking victims visas. So this is for victims who are a severe form of trafficking, sex or labor trafficking involving victims under 18 or adults subject to force, fraud, or coercion. So any victim under 18 or adults if they have those other additional things. The victim is present in the U.S. on account of trafficking. The victim must comply with reasonable requests for helpfulness in investigating or prosecuting trafficking, except for juveniles. If you're under the age of 18, then that doesn't apply. And if you can also show that there were physical or psychological trauma that would impede their helpfulness or cooperation, then you might also be able to get around that. Removal from the United States would cause extreme hardship, and that's something you have to show too. The last one that I'm going to talk about briefly that we see mainly in our courts is, oops, I think I went
Sorry,
far.
I got it.
Okay, is special immigrant juvenile status. This is very important because a lot of our juveniles really qualify for this relief, and it's immigration relief for unmarried children under the age of majority under your state law. It doesn't matter what my state law is or what Leslie's is or what Judge Weir's is. It's whatever state you're in. They must be victims of abuse, abandonment, neglect, or dependency by at least one parent. It doesn't have to be both parents. You can have one good, healthy parent as long as they're victims by one parent. And they must be, that must have occurred in the U.S. or abroad. To apply, they must submit required findings from a state court judge with jurisdiction over the care, custody, or dependency of the child. So this needs a state court to make those findings. It's the threshold level. If the state court makes the findings, it doesn't mean that they're going to get that special immigrant juvenile status, but if a state court judge won't make those findings, they won't get it. They can't get it. So we'd like to ask you now, in your cases involving immigrant victims, is there co-occurring, in your cases involving immigrant victims, is there co-occurring when your mother is suffering domestic violence and the child is abused by the child's father?
So there's about 247 of you on, and there's a checkbox up. Let's see how many of you can respond.
Okay, so it looks like over 50% now are saying they've seen that.
And okay, great. Thank you.
Okay. All right. So when have you seen cases where battered immigrants whose father, the child's father, has abandoned the child? Lots.
I think a pretty big number on that one.
Yeah.
So
and
what?
We do see a lot of that in our systems, I think. That's often they're kind of self-selected. They come in our system because of these reasons.
And one of the you might wonder, thank you very much, NCJ, for putting that up. You might wonder why we're raising that here. Why we're raising it is that many domestic violence victims and sexual assault victims that we work with have children that, in addition to whatever immigration relief the mother may file for, let's say a U visa, the child would independently qualify for SIJS. And that special immigrant juvenile status case for the child may give them a much faster path to lawful permanent residency than if they only join the mother on her U visa application. So it's really important to screen for special immigrant juvenile status for the children in the cases that you're working with, because that may be an option that gets them more quickly to be protected from deportation, which helps even in domestic violence cases where the perpetrator may be threatening to remove the child as well. So it's really, what I would say is, if you're talking about building a good, solid custody case before a court, one of the things that you need that really helps is identifying victims who qualify for immigration relief as early as possible after you meet them and begin working with them. Because as they begin, what we've seen and what the data shows is that social science data, that research that we've done, is you see that as victims begin to file for VAWA self-petitions and U visas, for example, they call the police more. They go to court more they begin seeking, more willing to seek custody, more willing to seek child support. All of that begins to build from that point. And so what we recommend is that people identify the cases early, and that for those of you that are lawyers and victim advocates who might be working on these cases, that it's important that if a victim files a case, that case be filed with sufficient documentation to show prima facie, to show that it's a valid case, that she can meet the prima facie test. Because if the application is filed without enough information, it could be denied outright, and I'll tell you what that denial means in this, what it will mean starting November 19th in a minute. And that once she files, she'll get something called an A number that she should memorize or carry with her, just like we encourage victims to carry their protection orders if they're immigrants. In case they become the target of immigration enforcement, they can show the immigration enforcement official that they already have a case in the system and that they're entitled to VAWA confidentiality protection, which means that the VAWA confidentiality means that they can't rely on perpetrator-provided information to use that against them to deport or remove the victim. So there's a new policy that's going into effect on, actually the slide should have been edited. Okay, I'm going to tell you this, I will make sure that the final draft has the correct slide here. This policy is going into effect on November 19th, vis-a-vis VAWA self-petitioners, U visas and T visa, humanitarian cases. And so what it means is that if a victim's case is denied on the merits, that case could be referred, or the case will be referred to Immigration and Customs Enforcement for removal, unless unless USCIS, U.S. Citizenship and Immigration Services, exercises prosecutorial discretion not to make the referral. So it's important that cases be well documented. It's important that victims get screened for other forms of relief in terms of 10-year cancellation would be one example, and that people file strong, well-documented cases. And we can provide more information on that if you have specific questions, and you can call us for technical assistance. Back to you, Judge Wirth.
Okay, so we want to go through this scenario. Clara met Eduardo, a naturalized U.S. citizen, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her 9-year-old son, Miguel. After Clara became pregnant and gave birth to baby girl Lupe, Eduardo decided to bring Clara, Miguel, and Lupe to the U.S. to live with him. When they arrived in the U.S., Eduardo took Clara, Miguel, and Lupe's passports and became physically and sexually abusive of Clara and abusive of Miguel, who tried to protect his mother from Eduardo's abuse. Eduardo also physically beat Lupe when he said she misbehaved. Within a year following their arrival in the U.S., Eduardo forced both Clara and Miguel to work for his family's business and never paid them for their labor. One night when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beatings with a belt of Miguel and of Lupe. When Clara intervened to protect the children, Eduardo strangled her until she passed out. The neighbors called the police for help. Clara talked to the police. When they arrived, the police arrested Eduardo for attempted murder and the child abuse, took Clara to the hospital, and placed the children in the care of the state. So, you know that. What forms of immigration relief would Clara qualify for?
This is another poll. NCJ, FCJ, can you put the poll? There we go. Great. Thank you, Alicia. So we'll take a few minutes. And which would Clara qualify for? The U visa, the VAWA self-petition as a parent of Lupe, the T visa, or all of the above? Okay.
Okay, so what do we have here? All of the above is the correct answer. 75% of people said that. And why is that? Well, the U visa, right? Clara is a victim of a crime. She would qualify for the VAWA self-petition because she is the parent of Lupe, who is the child of Eduardo. And the T visa, why? Because they're being forced to work. Okay?
Right. So, and there'll be many cases where people have multiple choices of which kinds of crime victim visas they can go for. Next poll, please.
All right. So, what forms of immigration relief would Lupe and Miguel qualify for?
The choices are both can self-petition, both qualify for a U visa, Lupe qualifies for a T visa, or all of the above. Judge Weir?
Okay, so let's see here. About 5% thought that, think that both can file the VAWA, both can do the VAWA self-petition. Do you think that's right, Leslie?
No. The reason it's not is that so here's the issue. Lupe can file for a VAWA self-petition because she was abused by her father. In this scenario, Miguel and Clara are not married, even though Miguel's a citizen. If they were married, then Miguel could qualify as a stepchild for a VAWA self-petition, but because they're not married, he doesn't qualify. The correct answer is that they both qualify for a U visa, and Lupe doesn't qualify for a T visa because she wasn't the one forced to work. It was her brother Miguel. So that's kind of how this works out. So you'll see kind of how different family members, whether there's a marriage or not, can make a difference in terms of which form of immigration relief they're eligible for. So next slide. Here we go. So now we're going to actually move on to some more core family. We'll spend the rest of the webinar on some core family law issues. From a jurisdiction perspective, it's important to understand, and this was illustrated actually in one of the in one of the questions earlier. Everybody has a right to a protection order. For example, if they were a victim of the domestic violence that would qualify under the state protection order without regard to immigration status in any state. Similarly, the residency for purposes of divorce is not lawful permanent residency. It's where the parties physically live and intend to stay, and immigration status is not a factor in that. Custody would be the same laws that apply in any kind of a custody case. Status doesn't play a role. And child support, it would be where the child or the non-custodial parent lives, just as in the case of anyone else. It's important to understand that divorce and annulment can have impacts on immigrants. So with a divorce, that's a trigger. If somebody is divorced, it starts a clock running, and they have 2 years from divorce to file for VAWA self-petition. It's also important to understand that divorce can cut off access to legal immigration status for, hold on one second. For, I'm sorry, somebody came in and I lost my train of thought. For students and people on diplomatic visas, work visas, etc. And so it's important to understand that if a divorce is occurring or somebody's trying to get a quickie divorce, that's something that, for example, if my husband were filing, let's say I was an immigrant and my husband was filing for a green card, a lawful permanent residency for me, if I got my lawful permanent residency and my divorce was final later on the week after I got my lawful permanent residency, I would be a lawful permanent resident. If the divorce became final the day before I got my lawful permanent residency or my interview with my husband for lawful permanent residency, I get nothing. And so it's not necessarily benign in these cases. The other thing that's problematic is that annulment, sometimes you'll see these cases, a family court judge might see a case where a perpetrator of domestic violence or somebody else walks in and they have like 3 kids, they've been married for 10 years, and he's asking for annulment, saying that there was marriage fraud. If a state court finds marriage fraud and based on marriage fraud issues an annulment, that finding could lead to, could be brought to the Justice Department, and the victim could be, the person who had that finding against him could be investigated for marriage fraud. So which is a criminal offense of marriage fraud, which would then lead to withdraw any kind of immigration benefit that person got. So again, annulment instead of divorce is not benign. So one of the other things, Judge Weir, just one thing I'd like to explain before I move on. Under immigration law, the definition of child includes stepchild. So stepchildren and children under immigration law are treated the same, which is very, very different than some, let's say, a custody case, but not that different than, let's say, a dependency or a delinquency case in family court. The judges, did I get that right in terms of how step-parent relationships are treated in certain family court proceedings? So that in a dependency case, for example, if a step-parent had been raising a child, they'd be served with notice as part of that proceeding, just like a parent would. Is that correct?
Well, they would in my jurisdiction, but
it's really complicated depending on your own particular jurisdiction. So many
but it can be sometimes in family court. What's interesting is under immigration law, they're treated the same, except that divorce can cut off the step-parent-stepchild relationship for eligibility, let's say, to a VAWA self-petition.
Right.
I'm just responding to one of the questions in the chat.
And I like your tips about annulments and agreements and rush through divorces, because we often see that in divorce court. And from a judge's perspective, if somebody comes up and says, we want to rush this through, we have an agreement, we're happy about that because we have 100 million cases and we want to get through them. But it should give you pause if there's an immigration issue or if for some reason the other side hasn't appeared. So there are reasons to double look at cases where it seems like somebody's in a really big rush and the other side may not have the appropriate knowledge base to decide if they're going to agree to that rushed case or if they are being defaulted.
That's right. So we want to talk now about obtaining custody of children for battered immigrants. So in what types of family court proceedings can the courts decide custody of abused immigrant children?
Type in the box your responses.
And I can't really see the responses, so.
Nothing's popped up yet. There's multiple people typing, though. So protection orders,
seeing some. Yeah, there we go.
Protection orders, custody, dependency, divorce.
Right.
Right. So they obviously any type of custody proceeding, be that arise in a paternity action, in a divorce, in a protection order, in an adoption, in a dependency or abuse and neglect action. Are there any others?
I think that pretty much covers them all.
So we're going to have a poll, another poll, and we're going to ask you, in your jurisdiction, do judges award custody of children in protection order cases?
And FCJ, a poll. There we go. So the results look like in most of your jurisdictions, they do, but in almost 20% of them, they don't. Judge Weir?
And that's, yeah, I think that's interesting because I think those numbers are a lot better than they were 20 years ago or in 15 years ago. But still, in 20% where they don't, that's problematic. And, I know even when I was out practicing and I'd hear judges say, just tell them to go file a divorce. Well, we know in immigration-related abuse matters that the victim often doesn't have the money to go slap down $5,000 for a custody proceeding, which is, a very common retainer for attorneys in these types of cases. So, I mean, that's just one more reason of training judges and for attorneys to be pushing for or on the issue of immigration abuse. Just go file a divorce does not fill in that gap of what happens between then. Is it fair? I used to always argue, is it fair for children to get pulled out of school and pulled out of daycare because there's no orders in place? Obviously, an order in a custody proceeding, outside, at least in my jurisdiction, that would, in a custody proceeding outside of an order of protection, would supersede the order of protection custody order. So, it's not a forever order, but at least it fills in that gap. The best interest of children is not being served by being left out there without a custody order. And children are often used as pawns. We know this. And we also know that victims, if the violent spouse grabs the children, we often know, and the other spouse doesn't have the means to go file a divorce and then get into court and get a hearing and get a temporary hearing for custody, we often know they're going to go home. So I'm glad to see that number up at 80, but it'd be better to see it at 100.
And we know that this has improved over the past years, but still has a long way to go. If it is a relief that's available in your jurisdiction, then it really should be considered by the judges as part of our access to the courts. There are very few cases where we will tell other litigants, yes, you can get this relief in this case, but I'm going to make you go out and file it somewhere else and do something else to get it. And that really has destroyed the access to courts. It also puts up extra hurdles for people to go through that they don't have to legally. So it is an education issue, it's a training issue, and I think it's a culture change. And hopefully we'll see those numbers get even better as judges realize that that's part of our obligation. If somebody asks for the relief that is legally available to them under a particular proceeding, we really don't have any basis to say, no, I'm not going to do it that way. I want you to file another case in another system to handle that.
Back to Judge Weir.
Okay, so you'll often hear, well, they're not a citizen, they don't have the right to file this. You hear, I used to hear defense attorneys saying that, they can't get an order of protection. Well, of course they can. Everyone's eligible without regard to their immigration. Well, not everybody's eligible, but your immigration status is not what makes you eligible to file for a civil order of protection. Also, the issuance of the order of protection will not trigger deportation. We often will hear that argued, that, Judge, if you grant that, he's going to get thrown, he or she is going to get, if she is the respondent, is going to get deported. Well, that's not true. A conviction, it's the conviction or finding that you violated a provision of the order of protection that is a deportable offense. So it's important to know that. It's important that attorneys and judges are trained on that. Because, again, we see a lot of things misrepresented to the courts, and we're doing a lot more training with judges, but we don't always know. So we do like to know, and that's why it's important to, present the law to the courts. And, again, the protection order issued against the victim can be harmful to the good moral character, and especially if it leads to a criminal charge for violating that order of protection. Victims and children often will need creative protection order remedies, and many of our states have catch-all provisions. We often see that immigrant victims want to stay in the home. That's one of the things, that they want to stay together. They just want the abuse to stop. So we want you to issue an order to stop the abuse or the harassment. You just be creative with what the remedies you're asking. These are just some examples up here. Stopping immigration-related abuse, it's important to ask for documents that have been taken. I think it's a very common tool used by batterers to take the papers of the victim and the children. It's important. Ask for those back. Order that those be brought to the court. I think that's an important thing to do. I often would do that. Sometimes ordering it to be done isn't enough. So I like to say, no, I want them brought to the court. Come back in a week and have them with you, rather than having somebody have to file a contempt action. Making appropriate findings about the existence of the marriage, the parent-child relationships, ages. We want to deter parental kidnapping. So you want to encourage judges to make solid orders regarding custody, support, insurance. A lot of times the argument is, I'm not working, I can't support her. Well, did they sign an affidavit of support when they brought her over here? That's important to know and use in seeking child support orders. I don't know if you have anything to add to that, Leslie.
The only thing I would say as to kind of creative remedies somewhat is all state protection order statutes protection orders don't require separation of the victim to get one. And many immigrant victims, what we know is that when they file a VAWA self-petition, they file a U visa, it can take, a year to 4 years to get work authorization. And many victims will stay with their abusers until they get that work authorization. So protection orders can be available that just say no further abuse, no unlawful abuse. And those work to protect immigrant victims in a very important way during that very dangerous time.
And when people come in, we have a lot of people that come in to ask to drop an order of protection because of financial issues. And we have found that if you do explain to them and have the advocates work on this, that say we can give you an order of protection that will allow for contact, but put in the clause, just like Leslie mentioned, the no unlawful contact, that we can often keep the order's protection in place.
And so just to give you, we've got about a half hour to go. So what I wanted to focus on is some of the, we're going to spend the next part of the time talking about some of the major arguments that abusers make, of perpetrators of domestic violence make in family law cases and talking about how you can explain to the court what the truth about immigration law and a victim's immigration status is, because they make allegations that the victim will flee or be deported and take the children, that they incorrectly make allegations that they have to have custody, they can't confer immigration benefits on the child. They might say, well, I have to have the child because she's financially unstable, but he may have caused that instability, things like that. And so we're going to spend the next chunk of time talking about how to respond or how judges respond and what some of the information that's most important to understand and what's relevant to what in custody cases as to the intersection of immigration and custody. Judge Collins?
Because most of the time when abusers bring this up, they're really using it as a threat against the victim. So our common response is that, it's not really relevant to custody because it really doesn't have anything to do with who's the best caretaker. It really doesn't have anything to do with who can be the best parent. It doesn't have anything to do with the best interest of the child determination, which is what we always use for our standards. And so there are many state laws out there, too, that say that you can't give custody to an abuser, that you have to give it to a non-abusive parent. But it can be relevant sometimes, so you can't just have a rule that says it's never relevant for any reason at all. So because it can be relevant, because we know that, like Judge Weir was talking about earlier, many times abusers do not get their immigrant status for their spouse because they're using it as a weapon. So they either don't file or withdraw the immigration papers. They will threaten to turn them in for deportation, and that can be part of the history of violence. So it can be relevant under those circumstances, and so that's why it's important that on each case you do a case-by-case determination of relevancy.
And I just want to chime in there. I was recently on a panel in my area with some other judges who all felt, yeah, it's relevant to the issue of who would provide, who would provide a meaningful relationship determination with the other parent. And everybody thought, somebody who's not bothered to file the papers, who's placing their partner at risk of being deported, they're not really trying to foster a good relationship with the other party, with the other parent, I mean. So, it's seeing judges are recognizing these are red flags, and so that is a good area where it's relevant, and that's all about training and having judges understand immigration-related abuse. So it's important.
It really is. And so what evidence can be presented to prove that the battered immigrant is the primary caretaker of the court? So this is a question. So if you can answer it, we would love to hear what your response is.
Right. So
and Leslie, I know I don't want to be ignoring. I saw, I don't know who this person is, Laura McFarland has asked a question twice about the immigration status being used against the victim. And I don't know if we have time to go into that.
We have, I think we have recorded webinars, or we could do another future webinar on VAWA confidentiality and discovery. So, for example, the perpetrator in a domestic violence case shouldn't be able to raise the immigration status. He can't prove that she got a VAWA or didn't get a VAWA, self-petition, or a U visa, because there's no information that can be released about the federal folder, and they shouldn't be able to even discover it from the victim in a family court case. There's very good case law on this, and so we can provide you technical assistance, and we can look at doing potentially a future webinar that digs into the case law. There's case law in family court, criminal court, and civil court cases precluding discovery of the victim's immigration case, which could help keep the whole issue out of the family court. In addition, we have some sample materials, so if you know a perpetrator is going to raise this, and let's say we're in Judge Collins or Judge Weir's courtroom, you could file a motion in limine saying that the immigration status isn't, should be the issues around immigration status and whether or not she's filed, depending on what your case strategy is. You could ask that be kept out of the family court case.
So we have some great responses to this. People talked about medical records, who takes the child to the doctor, who takes the child to the school, what do the babysitters say, what do neighbors say. So there are many different ways to prove who is the primary caretaker of the child, and a lot of great suggestions here about how that can be done. So absolutely, you can look at all that information and let all that information show who the primary caretaker of the child is. So when we talk about, go ahead.
Go ahead. Did I go too fast?
No, I just thought somebody had something to say. So here's so when we're talking about is immigration status relevant to custody, we really need to look at what the issues are. What are the custodial issues that we're handling in this particular case? Because if we find that one parent has abused the other parent of the child, then that might be relevant to find out we need obviously to find out who the abuser is, and if they're using immigrant status against one of the parents, why they're trying to use it. And so if a parent has an outstanding order of removal, that might be relevant because it might mean that the other parent has either, depending upon the circumstances, how do they have the order for removal? Did a parent turn them in to immigration? Is there other statuses available for them? So it may be relevant because you need to find out who the abuser is so you don't hand a child over to an abuser, and that abuse can take many different forms, including immigration abuse. So when you're looking at the best interest, which we always look at in all of our custody cases, the best interest statutes of all of our family codes do not list immigration status. So that is not something you consider as part of the best interest. English language competency is also not listed as a status or a factor for determining best interest. So if somebody says that to you, they're asking you to go against what your statute says you consider for best interest. All states have provisions that tell us we should not award custody to batters. That's no longer an open question. So you really need to know that with respect to the issues of who the primary caretaker is and who has the parenting skills of each parent, immigration status is not relevant to that. The ABA Center has given us some help to that, and we have a slide on that that goes through what the ABA position is. So it really tries to eliminate the issue of using immigration status as a reason for the courts to award custody without consideration of other factors or at all relevant in most cases. And it says parties should not be able to raise, and courts should not consider immigration status of domestic violence victims and their children in child protection orders, custody, divorce, or child support proceedings. And batterers whose victims are immigrant parents use threats of deportation to avoid criminal prosecution from battery and to shift the focus of family court proceedings away from the violent acts should be recognized by the courts as an abuse technique. We don't want to be part of that abuse. And so we do not want to condone those tactics. We do not want to encourage abusers to use immigration. And so we can't condone those tactics because children will suffer. And so that's why we need to be aware of this and use the correct factors in determining custody.
And this is a good thing to share with the court, or if you're a lawyer, to share with the court, or if you're an advocate who works with attorneys who are in the courts, make sure they're aware of this. We're not bound by the ABA Center on Children and the Law, but it is meaningful to us, to most of us, I think.
And I think really most judges want to do the right thing. I mean, they really do.
That's right.
They don't know it.
Yeah.
And they may not know what the standards are. They may not have had, we talked to a lot of judges who say immigration cases never come up in their courtroom. So they may not have thought about it before because they just aren't recognizing these cases. So it's always good to help the judge make the right decision, and giving them any assistance you can will be appreciated by the judge.
And judges, one of the things I want to mention, this is Leslie again, is that when you're talking about the effect of domestic violence on children, it includes not only the co-occurrence of domestic violence, but it also includes the effect that witnessing and living in a home where domestic violence is continuing to occur has on the child's emotional, brain, physical development. We'll send you in a link after the webinar, we can send you some more materials where you can dig into that and potentially present that evidence where relevant to the judges as well. I raised this case.
All courts are trying to be more trauma informed, and so I think when you talk about it in terms of trauma to the children and how, because many judges would say, well, he may have beat mom, but he didn't beat the kids, so there's no problem. So I think it's really important to bring that trauma to the children forward, because courts are getting more and more aware of that, and it's great to have that reminder.
Right, and this case that I'm sharing here was a unanimous decision by the Nebraska Supreme Court, which recognizes it was done in a child welfare context, but it's got really good language about the constitutional right to care and custody of children absent unfitness, and those rules that apply in terms of best interest of the child and how courts make the determination applies to all families without regard to immigration status, whether somebody's detained or deported, etc. And there are mechanisms by which, if a victim decides to return home or go forward and that person is the primary caretaker, a state court judge could decide that, she can straight and get a copy of the passport for her child and go home with her child, as opposed to leaving the child at risk for harm from the abuser. We have new tools available that we'll share with you. Rocio shared them earlier in our Special Immigrant Juvenile Status book, where you can look up all of the best interest statutes by state on a state map and see what states have similar best interest factors to yours for purposes of case law and other things that are very useful. And this is a little bit of an example of what it looks like on domestic violence, and at the bottom of this map you can see all of the factors in all of the state statutes. And when we talked about, Judge Collins talked about the fact that no state statutes include immigration status as a factor.
Okay, so we want to talk about some myths and facts as to that we often see arise. So we're going to do a poll here. When a parent is undocumented, their deportation is imminent. We hear it all the time in the courts. Is that true or false?
So it looks like, still voting, or well over 100 and something of you believe that it's false. And in fact, that it is true that it is false. And so what I wanted to do is very briefly, this is information from 2013 and 2017 about enforcement priorities at DHS. And you might wonder why I'm talking about this in a custody case. As you're talking to judges, if you can show the judge or the court, if the opposing party is making allegations of that you're going to, your client's going to be deported, et cetera, or that everybody who's undocumented is immediately at risk of deportation, which is also not true, how you can educate the judge about who's most at risk. And those are people convicted of criminal offenses, anybody that has an open criminal charge or offense where the case hasn't been resolved, people who have committed acts that are chargeable as criminal offenses, drug offenses, gang offenses are an example, and people who are subject to final orders of removal or didn't, or were ordered removed and didn't leave the United States. And then it could be somebody who's abused a public benefit program or made a misrepresentation to the government or is some kind of a public safety or national security risk.
And I think these are really important.
When you look at the removal data from ICE from 2013 and 2017 and you compare them, you can see that there are some changes, but by and large, criminal convictions and pending criminal criminal cases are the largest bulk of people removed, and next largest are people who have, have open immigration court cases or have been ordered removed. And many, many, many of the clients that we serve and people that come before the courts don't fit any of those categories. Judge Weir?
Okay, so let's say just before I ask this question,
Sure.
even though people are answering, which is great, there's so much in the news right now about immigration, and these are, there's a lot of talk about removal and deportation, and people are just going to be thrown out. I mean, these statistics or ICE removal data from 2017. Overall, they're still applicable in 2018, aren't they?
From everything we're seeing, yes, that there hasn't been a dramatic shift. These are the enforcement priorities that are still in place. Okay.
And I just think I just wanted to throw that out there because I often hear, well, things are changing. Well, and there's a lot of talk, but doesn't necessarily mean it's all people are being picked up. I think they are in some places, but I don't know if that's overall. So, okay.
And I will just say that, as Judge Collins mentioned earlier, it's very important if you're working with an immigrant victim and that they get stopped, that they tell that they're a victim, that they have a case already filed, that they tell the officer they have a case, that it's important to file cases earlier because it goes into a red flag system at the Department of Homeland Security that notifies immigration enforcement that this is a victim and that they should carefully consider or possibly not act on tips they receive. So that's why filing early is so important. It's the best protection you can offer people in this day and age. And so it seems like, go ahead, Judge Ware.
Well, it looks like really not a high priority for removal in the majority of the cases that you're dealing with for one of the parents. So, I mean, that's a good thing, I guess.
Next slide. Yeah.
So when an abuser is arguing that the victim's immigration status undermines the children's stability because they're claiming that the victim's going to be deported, what are we seeing?
So that when the court makes findings, so for any time a judge is going to make findings of domestic violence, extreme cruelty, child abuse, or sexual assault, and the extreme cruelty, for example, could come up in a for-cause divorce case or a property division case or something like that. Anytime that's true, that those factual findings have been made, the victim will qualify for immigration relief, and that's one of the things that we need to train judges on, and we need to tell judges if we're in cases before them so that they don't use whatever presumptions they may have about somebody being undocumented, because many people might be actually on the path to lawful permanent, have a path through one of the crime victim-related forms of relief.
And Leslie, if I might, that's also why it's really important for judges to make appropriate findings. So if you're a judge listening to this, that's why it's important to not just check a box, but to actually make the findings. And it's important for advocates or attorneys to make sure that when you're getting an order signed, that those findings are very clear and precise about the language, that it's not just generalized or silent about that, but you need those findings.
And it helps for the court to be able to go back and look also at the findings when for instance, they're reviewing a certification for a U visa, or certainly being detailed in SIJS findings or the other.
And when a juvenile is going in, perhaps for their special immigrant juvenile status, if they have an order from another court saying there was extreme cruelty or what happened, then that will help them too. So the findings that you make, if you make them, the findings are important to document.
And it's just important to understand that under immigration law, abusers can sponsor their spouses and children without regard to custody. It's not a factor. And that immigration-related abuses we've been talking about in this webinar can be explained that, he's the reason she doesn't have legal status and that she can't work and doesn't have a driver's license, etc. Judge Collins?
So as we get through this, one of the things that we often do in courts is we love expert witnesses. You know, we really love them because they can give us information that we wouldn't ordinarily have. So if you can get an expert witness to give us correct information about immigration law, that's great, because it's very difficult to get correct information about immigration law from a lot of attorneys who practice before you in family court because they don't often know it. And if they go to the cases to look it up, the cases are not always correct. So it's very important that they get the correct information, and an immigration expert can really provide appropriate information that the court can rely on about different protections that may be available, why that they're not going to be removed because of the DHS enforcement priorities. And it would be really helpful to courts if you can, because that will help us make a right decision. And that kind of covers that. So who is least likely to flee with children from the United States? If you could answer that question. Who is least likely to flee? U.S. citizens, undocumented immigrant victims, mothers, dual national parents, or multiple entry visa holder parents?
Okay, we have a pretty smart group here.
Yeah.
That is true. It is the undocumented immigrant parents, or mothers or parents, because they can. Every other group here can freely enter and leave and come back to the United States. And it says the ability to leave freely and return freely that makes it easier to do things like international child kidnapping. And this is actually, State Department data found that, for example, dual nationals and multiple entry visa holders, but are the most likely to leave with kids.
So our next question we'll get to is true or false. The abusive parent with status must be awarded custody in order to sponsor their child for legal immigration status. Is that true or false?
Okay, so most of you say it's false. That's correct. There are almost no forms. I think there's one odd form from somebody filing for abroad or something of immigration status that requires custody in order to do it, and you don't have to do it. So that people can file, it's not required of citizens, lawful permanent residents, work visa holders, student visa holders, all of those. Custody has nothing to do with whether or not somebody who has a legal status can sponsor a family member.
And again, that's making sure that the courts understand that. So going back to your expert, if you need to bring an expert in for that, you need to do it, because that's a pretty common argument out there.
Yes, it is. So now we want to know what options might be available to a battered immigrant when the abuser seeks custody, claiming that the victim has no livelihood. What options might be available? Child and spousal support, victim files immigration case and gains legal work authorization, sees public benefits available to the child or the parent under your state law or federal law, and or D, all of the above. What do you think?
It looks like a few more seconds to vote. And it looks like most people are saying, Judge Collins, D, all of the above.
Yeah, it's a pretty smart group we've got here. The immigrant victims will qualify for one or more of the following types of relief, and we have them listed there for you. And I'm not going to read the slide because I know we're running out of time, but they have the opportunity to get a lot of relief that's available to them. So they are not precluded from getting that kind of relief.
And when you file relief, if you file early and file good, strong cases as soon as you can, VAWA self-petitioners will receive work authorization if their abuser is a U.S. citizen in about 4 months. It might take a little over a year for somebody whose abuser is lawful permanent resident. It's running about 4 years for U visas, 1 to 2 years for SIJS, and 6 to 8 months for trafficking victims. So you're starting them on a path where work authorization becomes much more available more quickly. Judge Collins?
So how many times do we have people come in and say, well, I just can't provide support? You know, I mean, really, it happens all the time. I just can't provide support. I don't have the ability to support my family, my children. So what do you do if you have a non-custodial immigrant parent that says that? How can you establish their child support ability? So we're really lucky in this case because the parent, the non-custodial citizen spouse must submit an affidavit of support in family-based immigration cases. So they have filed an affidavit that they promise to support their family member for up to 10 years or until they become a U.S. citizen. In that, they have to provide information, including their tax information, their current employment, self-employment, and proof of income. So this document is prepared when they're trying to brag about their ability to provide support. So they're giving all the information that they are able to provide support when they provide that affidavit of support. And courts have used that then, saying, well, I can enforce this affidavit of support as a contract. I'll use it to set child support levels, and there's no duty to mitigate. So these are really important documents to have because it really gets rid of that argument that, gee, I'm so sorry, but I can't provide support. And so that's important to look at.
And that's this brings up another issue. When we talked about ordering in orders of protection, ordering people to the batterer to turn over immigration papers, because that affidavit of support is something they've probably got in their papers, and trying to get it from immigration takes a long time. So trying to get that affidavit, either using discovery to get that affidavit to present to the court, or it's important to ask the court to order those papers be turned over to the victim in orders of protection.
So talking about child support now, what kind of proof how might people prove a non-custodial parent's income? Let's say they're working under the table. Judges?
So you can do that by using your actual child support guidelines. I mean, you can impute a certain amount of income, but you can ask for their evidence of earning capacity. We can attribute income if they say they're working, but under the table, there's a minimum wage that you can find. So you can actually impute a lot of income to them in the same manner that you really impute income to any person in your court that says, I'm not working, I can't pay a thing. And you can try to find out how they are supporting themselves. How are they paying for their cable bill? How are they paying for their telephone? Right. And so you can use the same tools you use in every case to find out how you can find out the non-custodial immigrant parent's income.
Yeah.
Judge Weir, did you want to add something?
No, I absolutely agree. It's really, the same analysis outside of the affidavit of support. It's really the same analysis as we do in non-immigrant folks' cases. So,
right, and the one thing I'll add is just a reminder again that if you can tell a judge that by issuing court-ordered support, and if you have an expert witness, this would be useful, you are actually setting that the parent who pays up to have a documentary record that they paid that will help them in any immigration case they might have in the future. In closing, a couple of things we wanted to talk about public benefits, and just say that when you're looking at the economic picture, the immigrant may have U.S. citizen or lawful permanent resident children who qualify for benefits that the parent can file for on the children's behalf, and that could be part of the puzzle that you could explain to the court. We have soft launched, we're almost done, but we haven't quite finished. We've had a benefits map on our website for a number of years that we're reformatting and updating. This is just an example of one of the pages, and what you'll be able to do is you can go to our benefits map. It'll give you different maps, one for TANF, child care, health care, etc. And then you can click on your state and it will show you, let me see if it's got it. Yeah, it will show you what's available to VAWA self-petitioners or U visas in your state, and then at the bottom it will link to a detailed state chart so that we can give more information, so you can get more information on whatever benefits that they might be eligible for. Let's go here. Judge Collins, do you want to talk for a minute? This is our last.
I know we're running out
about how to get this information into the court record.
This is really, really important. Make sure you get the information on the record. Make sure the judge's findings are on the record. Prepare the order, and if the judge doesn't prepare their own orders, then ask the judge if you can put those findings in. It's really important in almost every way in immigration law that when the court makes these findings, that they're somehow reduced to writing so that you can get it. And if you can't get it because the judge won't do it for some reason, get a transcript where the judge makes those specific findings, because that'll be very important for all the immigration relief that you're going to be seeking. So give the court as much information as they can, help them make the right decision, and use experts when you can.
And so in closing, I just want to say I really appreciate how active you have been in this webinar, asking questions. We are going to send around a link. This isn't the one. We'll send around the right link to the recording of the webinar and a web page of materials. We'll also email you. We have a set of materials that were developed under a State Justice Institute grant that go beyond the particular focus of this webinar of family court and custody and protection orders to other issues that gives you some resources into other services, other assistance you can find, other materials you can find online through our web library, and then we're always available for technical assistance. Thank you so much for taking your time to join us today. I hope you have a happy holiday season.
Thank you.
Alicia, back to you.
Thank you all so much. Have a wonderful day. You'll be closed out of the webinar now.
And you'll be receiving an evaluation. Please fill it out and return it to us. Thank you so much.